Telugu ప్రేక్షకులందరికీ hello and welcome back to yet another fabulous episode of our talk show with expert. మనతో ఉన్న మన immigration expert Emily Newman garu. Emily, thank you so much for being on the show today.
Thanks so much for having me.
All right. Call our expert Emily on 1-833-882-8872. The number again is 1-833-882-8872. To all our viewers, thank you for being so patient, Andy. We were just sorting through some technical issues, but we're back online now and let the show begin. You can also watch us on Yup TV, Facebook, YouTube, Sling TV, World BB TV, and Dish Network. All right, guys, coming on to the topic for today, the Eagle Act. S-3291, revolutionizing U.S. immigration by phasing out the per country limits. Now, Emily, we've been talking on many occasions about, removing per country limits. Is it even feasible? Is it something that should happen, needs to happen? What are some of the pros? What are some of the cons? Is it going to happen at all? Is it something that we can, see in the near future or not? If yes, what does this mean for us? If no, still, what does it mean for us? Can you tell us?
Yeah, so I think that whether this can actually pass this time around, we've been through this so many times, going back 10 years. I think it really depends on getting the message out, putting the right message on things, because there's a lot of mixed feelings from other people about this particular bill. And I think a lot of it is based on misconception. So we have to be clear on what the bill does, clear on what it doesn't do, how it's going to impact other people, how it doesn't impact other people, so that more people will feel comfortable with it. We need to get our story out more, let people understand how this per country cap is negatively impacting people. The more we can do that, the more likely we have to actually get it across the finish time this time. The last time we got so close, there just wasn't enough time to pass it. This time around, they do tend to bring it forward in the odd years so that we have basically all of next year to get this passed. So hopefully we can get it out of the subcommittee and onto the floor. And this time it is proposed by the Senate. It didn't start in the House. I think that's a good sign as well. So we have a lot of things going for us. Even though we've had failures in the past, I want people to think about how much progress has been made. We still haven't gotten it across the finish line, but there has been progress every year. So the very first year that this was proposed, there were 5 co-sponsors on the bill, and it did not pass. The next time, 11 co-sponsors. Then we had 14. Then 147 2 years later. Then we bumped up to 300. And we had 300 in the House in 2020. So we're clearly making progress. And each time the bill comes forward, we come up against new obstacles. We figure out how we can modify the bill to make those people happy, and we move it forward. So I think this bill encapsulates all of those failures we've had in the past to hopefully give us a chance of moving forward.
Gotcha. And anything else you'd like to add at this point? Like I was asking about, what does this mean for us? Is it, if it passes, then what does it mean? If it does not, what does it still mean for us?
Yeah, so what this bill does is basically over a 9-year period, it phases out the per country limit so that anyone who's in the employment-based category is all on an even playing field, regardless of country of birth. So now we're looking only at qualifications, which specific category, EB1, 2, or 3, do you fall under, and what are your education qualifications for that. We're not looking at country of birth anymore. So that's definitely positive for people from those backlogged countries, because right now it's the populous countries that are getting this 100-year-long wait. So certainly we should be seeing faster green cards for people from India and China. Now, it is a 9-year transition. So the first of all, it doesn't even start until the second fiscal year after it passes. So it's going to take some time for them to implement. And then over the next 9 years, they're going to slowly increase the number of green cards that can go to anyone and reduce the number of green cards that are reserved for the rest of the world or countries that use smaller amounts of green cards. They also provide that within, basically after it passes, if you have an I-140 approval for 2 years, you can file the 485 even if a green card is not available to you during the next 9-year period. The great thing about that is we can get the message out that for everyone, regardless of where you're from, it doesn't matter. The most you'll ever have to wait in the next 9 years is 2 years. I think that's fair for everyone because right now we all know rest of world doesn't have much of a wait. This right now is the first time they've really had to wait at all. They have a cutoff date for the October visa bulletin for the first time ever. So they're just now feeling this versus people from India and China who've been dealing with these backlogs for 2 decades now. So everyone's on an even playing field and everyone still gets to file the green card within 2 years. So that's an important thing to point out. Another huge advantage of this bill is once you do file your 485, even if it takes longer to receive your green card, your kids will not age out. So that's a huge problem that we're just now starting to see where, you know, with these long waiting periods, people who grew up here basically have attended their whole school here, bachelor's degree, you know, they're aging out of their parents' green card, of their parents' status, having to move on to their own F1 only to try to get it through the H-1B lottery and end up in the exact same line that their parents are in, or go to the family-based category, which there is, you know, once the parents receive the green card, they can sponsor their older son or daughter as a green card holder, but they have to remain unmarried for that for who knows how long while they wait. So that's not really the best option. So if we can get the kids to stay with the family, not let them age out, that's going to be huge. And for the, you know, a lot of people were concerned about the nursing shortage, the healthcare worker shortage that we have, and how that would impact nurses coming from the rest of world or Philippines where there's very little wait, and now they're going to have to wait. But there's actually a carve-out provision that sets aside green cards for the Schedule A categories. And if we tie that into the artificial intelligence executive order that came out a little while ago, they're planning on updating Schedule A to even include additional occupations. So we might have a carve out of Schedule A that's good for healthcare. We have the Healthcare Workforce Resilience Act that we could pass along with this, which also makes more green cards available for healthcare. And for the people who are against it because they think that it's going to harm U.S. workers, there are already protections there that eliminate or try to reduce the harm of U.S. workers. We have H-1B rules that require certain salaries. The PERM labor certification makes sure that anyone who's receiving an employment-based green card is not harming U.S. workers. And this bill actually adds additional labor protections. They're adding additional requirements to H-1Bs. So if you are getting your very first H-1B, the company has to first post a job for 30 days to see if they can find a U.S. worker before they can proceed with the lottery. So I feel like it, again, kind of hits all the right boxes for all the different groups that have been opposed to it in the past. So hopefully we can get this passed. Another thing I think that people need to be aware of, you know, once the bill came out, every comment I saw on social media was, here we go again. We know it's not going to pass. You know, it was very just disappointment, I would say, even though this bill is actually bringing a lot of good. And I just want people to remember that, yes, it's failed before, but every single one of those failures is going to set the stage for success at some point. Now is not the time to give up. You've got to keep at it. You've got to keep advocating. We're going to have a letter posted on Reddy and Newman website, rnlawgroup.com, where you can put in your information and send it off to your personal senator or congressman's office and ask them to support this bill. You need to share your story. Think about submitting an op-ed or an editorial to your newspaper in your local town so people can become familiar. You would not believe how many people have no idea this rule exists and that our immigration is so discriminatory that we're actually deciding who gets a green card based on something that you have no control over. So I think if more people were aware of that, there would be more support as well. So those are kind of my 2 or 3 cents on the topic. I really want people to just not give up.
Okay, just one quick question though. So if they remove this per country captor or whatever, how does it, so what kind of pushback can we expect from the countries that, haven't had to wait, like you said, till now, but have started to feel that as of now?
Mm-hmm.
And then would there be an impact, would their waiting times be lengthened because there are so many more applications that are coming from like India or China? How would that impact them, and what kind of pushback are you getting because of that?
Yeah, we are definitely already seeing the pushback, but what we need to tell these people is if you're currently rest of world and in line right now, you are not impacted at all. You're going to get your green card before this bill ever takes effect. And we've got 9 years before it technically impacts you. So the people that this bill would really impact are like middle schoolers that are still have to go through high school, still have to go through college, not even thinking about coming to the United States. So why are we so concerned about today's rest of world who's in it for me? Yeah, I understand, it's not great for you, but it's good for me, so let's keep it. No, it's still going to be good for you. By the time this actually kicks in, anyone who's currently in line is already going to get their green card. And if not for some reason, they still get to file the 485 maximum 2 years. So no one has to wait more than 2 years. So I think that's really important to make sure people are putting the word out and making people aware that anyone who's out there today who's possibly in line for rest of world is not impacted by this in one bit.
Okay, great. And you also mentioned a really good thing, which is the aging out of kids. That's not going to happen anymore, right?
Right. So under this bill, for once you can file after that 2-year waiting period of your I-140 being approved, assuming at that point your child is still under 21, you file the 485, even if it takes you 10 years to actually receive the green card and your child turns 30, they will still receive the green card with the family.
Gotcha. Okay. Thank you, Emily. That's wonderful. Okay. Anything else to add before we start taking our callers for today?
Yeah, I think it's important to be prepared to, again, like it's going to be a lot more about messaging and being smarter with the messaging. There's a lot of people out there that, say a lot of racist things or very derogatory things on the internet, on social media. It's important that we don't drop to that level and do the personal attacks against them. We're not going to convince everybody, but if we can share facts, dispel some of the myths, I think that we'll get a lot further than we would if we start calling other people racist for not supporting the bill and that sort of thing, which has kind of happened in the past. It turns off people who might actually want to support us. So it's more important to be fact-based and positive and empathize with the other side, but focus on how this brings equity, how it brings fairness, how it doesn't increase the number of green cards, because there's a lot of anti-immigrant people out there too that think, oh, we're just giving away green cards now. No, we're not doing anything different. So there's so many different messages that we need to be prepared to get across so that hopefully this time we can be smarter and make more progress than we did in the previous years that this bill has been brought forward.
Gotcha. So empathize and educate seems to be like the big 2 takeaways.
Yes, absolutely.
Because I think, like you said, with the facts and the statistics and everything, if we are able to educate people as to what this bill actually means and what it does mean to the future of America, I think that we can get more people to support it and more people to come on board. Thank you for that, Emily. Awesome. So let's start taking our callers. Let's take our first caller for the day. Okay, caller, first caller for the day, caller with number ending in 5106. 5106, we're ready for you now? No?
Yes, ma'am. Can you hear me?
Hi, sir. Thank you for calling. Yes, we can hear you. Please go ahead.
Thanks for taking my call. Hi, Emily. I have a question. if I have a EB1A I-140 approved and my pending 485 application with EB2, how should I transfer the underlying basis from EB2 to EB1? Could you explain me the steps or process?
Yes, and your EB1 priority date is current?
Yes, it's a priority date is current right now.
Okay.
In EB1.
So, yeah, the difficulty that you have is the transfer of underlying basis process that they came up with in 2021, 2022 won't work in your situation because for EB1A, you don't submit the supplement J form, which is the normal way that we're doing transfer of underlying basis now. So what you're going to be doing is whatever field office or service center your 485 is pending at, you need to send a letter. You need to send a copy of your 485 receipt notice and a copy of both I-140 approval notices. And then in your letter, you're going to say, I have a pending 485 with this receipt number. I originally filed under the EB2 category based on this I-140 receipt number. I now have an I-140 approved in the EB1 category based on this receipt number. Please adjudicate my I-485 in the EB1 category. You're going to mail that. And then you are likely going to need to reach out to your local senator or congressman's office for assistance because there is no way to contact USCIS to confirm that they have received your letter or that they've done anything about it and actually transfer the underlying basis. So I would say after 30 days, mail that letter again and then reach out to your congressman or senator for assistance with a federal agency. Give all the details. They will reach out to USCIS on your behalf and let you know, hey, they don't have it in EB1 yet. We'll help you get it that way. Or, hey, yes, they did get your request and they're working on it. That's probably going to be your likely outcome, and you're probably going to have to follow up a number of times.
Okay. So what about my derivatives? Do I need to send a letter along with my derivative details?
Yes. So in the same letter, you can include all of your derivatives I-485 receipt numbers and include all of their receipt notices as well and ask that the entire family be adjudicated in the EB1A category.
Okay. Okay. So I no need to ask any help from employer, right? Because since it's a self-petition I-140.
That's correct.
Okay. Yeah. Thanks, Emily. Yeah. Thanks, Nitya Garu. Yeah.
Thanks, sir. Thank you so much for calling, Andy.
Yeah.
All right, let's
Thank
take
you.
our next caller. Yes, thank you, sir. Caller with number ending in 4795. 4795, we're ready for you now. Hello?
Hi, Andy. Are you able to hear me?
Hi, ma'am. Thank you for calling. Yes, we can hear
Hello?
you. Please go ahead, ma'am.
Yeah. Thank you, Ms. Newman. Thank you, Nitya Garu, for taking my call. So it's regarding H-1B wages. Actually, my H-1B is up for renewal, and so far my LCA is filed under level 3 wage level. And right now I am in California, and my salary is less than the prevailing wage. So can I file under level 2 wage level? Or what are the chances of rejection if I do so? And because my employer is saying that he has no funds to file me under level 3.
Mm-hmm.
So what are the chances of rejection? If rejected, is it the end of H-1B? What are my options?
So I don't recommend going down a wage level when the job is exactly the same, because obviously your employer chose level 3 for a reason last time around, because the job is at a senior level or it's supervisory, or there's some particular reason why that particular wage level applies to your position. So if you're doing the exact same job, they need to be continuing to pay that level 3 wage. Now, definitely the wages increased ridiculously in California on July 1st when the new wages came out. So I would suggest that your employer look into using private wage surveys, which are a little bit more reasonable and a little bit more in line with what the actual salaries are now in the current market compared to what they were in 2021, 2022 when things were crazy. So that would be the first place I would look, is to a private wage survey where you can still file your renewal and it still meets the requirements without trying to go down a wage level for the same role, which I definitely wouldn't do. If they were to do that and USCIS sees that the position doesn't qualify for level 2 and it should be level 3, they would just deny the extension. If that denial happens after your I-94 has expired, that's going to put you out of status and you'll start accruing unlawful presence. You could then exit the U.S., have the same employer file another petition for you to correct the error, or file a transfer to another employer. They would have to file that for consular processing. Once it gets approved, you apply for the H-1B visa stamp in your passport at the consulate, and then come back into the U.S. to regain your H-1B status. So it's definitely not fatal to you in your status going forward long term. But it would be best for them to not try to reduce the wage level now for the same exact role.
Oh, okay. So all these, we have these negotiations and they are ready to give us that, but right now I don't want to leave the company because of some health issues, and the market is down right now, so because of various other things, circumstances. So I'm not able to quit the job or forfeit this one. So what are there any other options that I have?
The private wage survey is what your employer should be looking for to see if there is a wage survey that meets their current requirements. So in other words, don't use the DOL
the only
wages.
option I have is find another. So the only option I have is to find another employer who can afford me, who can apply for this.
No, I'm saying your
level,
current,
right?
no. Your current employer can find a private wage survey, not use the OFLC online wage library. They just have to look in a different place for their wage survey, because the employer has a choice. They can choose to use the Labor Department survey, or they can provide their own survey. There are plenty of surveys out there publicly available that they can utilize instead of using the DOL's wage survey. And the private wage surveys are generally more in line with what today's market is. And so they may be able to afford that salary if they use the correct survey.
Oh, okay. Yeah, okay. So another wage survey I should go through. So that's the only option. So, and I have one more question, I'm sorry. So if they are giving me an option, I can give an address where the wage that they are giving suits me. So will it put me under any trouble because I'm not legally present over there? In person, I'm not there physically. So
yes, don't
it's
do
not
that.
happening, right?
That is fraud, misrepresentation, very bad for your future immigration, so do not do that. You could move to a place where a level 3 wage is something your employer can afford, and you can work remotely from that location, but you definitely cannot use a wage survey that does not go for where you're actually living and working.
Oh, okay. Got it. Thank you so much. That's my question. Thank you.
Thank you, ma'am. Thank you so much for calling.
Yeah. Happy Thanksgiving, everyone.
You too.
Yeah.
You too.
Happy Thanksgiving and Nitya garu to all our TVASIA team. Thank you.
Perfect.
Thank you.
So
Bye.
much. Yeah, appreciate it. Okay. Emily, I'm just going to take a few questions from our live chat viewers as well. Let's take the first one. This is from Venkat. He says, I'm on H4 EAD. Can I work 2 full-time jobs each 40 hours a week? One job has outside business activities policy agreement restricting not to take up second employment. What happens if I sign and take a second job?
So from an immigration standpoint, nothing happens. Your H4 EAD allows you to work for 1 employer or 10 employers or anything in between. You can do W-2, 1099, you can own a business. You can invest in a business. You can do anything on an H4 EAD. Now, you've signed some sort of agreement, so you need to perhaps talk to an employment law attorney in the state where that agreement was signed that can review it and tell you what are the consequences going to be if you break your agreement with them, because you may have to pay them money, they may be able to fire you. I don't know what's in the agreement, but from an immigration standpoint, no problem at all for your immigration, even if it's a violation of their agreement and they fire you because of it. It doesn't hurt you in any way for your future immigration.
Got it. Thanks, Emily. Next question is from Kishore C. Says, is it okay to have multiple I-9s for two employers? Can I hold more than one W-2 from multiple employers?
So the I-9, I think a lot of people misunderstand what exactly the I-9 is. It has no impact on anyone's immigration status. The I-9 never gets submitted to the government. So by choosing one document over another and submitting an I-9, you're only submitting it to your company. The company hangs on to it. They don't like file it with the USCIS or anything like that. What the whole purpose of the I-9 is to make sure that you are who you say you are and whether you're authorized to work or not. So, you know, if you are joining multiple employers, every single employer should have you fill out an I-9, and there's no problem with doing that as long as your particular immigration status allows it. So if you're on an H-1B and you want to work for a second company and you are, you know, filling out an I-9 for them, well, you can only do that if you have an H-1B with a second company. You need an H-1B concurrent petition filed. But if you're on L2 or have an H-4 EAD where you can work multiple jobs, that's totally fine to have multiple jobs, and you are going to submit an I-9 to every single one of those. But remember that I-9 doesn't have any control over your immigration. It doesn't go to the immigration service in any way. It's just the employer's way to document that they checked your status to make sure you are who you say you are and that you're authorized to work.
Okay, gotcha. All right. Sundar Mekala says, I'm on an L1 in the US and is valid till 2025. I'm planning to change my status to H1B, which was cancelled without prejudice. Is this COS possible using the H1's expired H1 797, which was August of 2022?
So when he says canceled without prejudice, I'm assuming he means the visa stamp that's in the passport. So he must have had an H-1B in the past, went for H-1B visa stamping, got the stamp, and then later got an L1 stamp. And because he got the L1 stamp, they canceled the H-1B stamp because you don't need both. So if assuming all of those things are true, then that canceled without prejudice has nothing, doesn't stop you from doing anything. It specifically is without prejudice, meaning it's not going to harm you in any way. It's just canceled because you don't need two visas. So what determines whether you can kind of resurrect an old H-1B is, have you reached your 6-year limit of H and L time combined? And if not, were you actually counted in the cap when you got that H-1B before? And in your case, assuming you got the stamp, you were counted in the cap, and you can utilize that old H-1B to switch back to H-1B status, assuming you've not hit your 6-year limit, even though that H-1B has expired. There's no limit on when you can resurrect that old H-1B that you never used.
Got it. Okay, cool. Thanks, Emily. Let's take our next caller. Okay, caller number ending in 8858. 8858, we're ready for you now. Hello?
No, that H-1B has expired. Hello? There's no limit on when you...
Hello. Yeah, 8858.
Yes, hi, sir.
Is it? Yeah, hi. Thank you. Thank you for the call. And I called, like I'm watching this show last 2 to 3 years, and thank you for all the help over here. I'm trying to get the information, like today's news is good, like if it will pass, it will be helpful for everybody. Right. But my question is, my priority date on EB2 is March 2015, and I was hoping like the dates will come forward and we all will get the green card, but it's unfortunate. So I'm wondering to know like how many green cards or 485 applications are pending on EB2 India? As of now, like it moved up to December 2014, then it moved back. So how many are pending? And the numbers are including the family numbers, it's counted. And say there are 30,000 pending in EB2, then some of them must be already filed in EB3 also, some of them in EB2, many of them might have already received the EAD. So is this particular number removed those duplicate EAD numbers or not? Like those duplicate 485 applications or not? So that's what I'm wondering, to do
all are great questions.
Yeah.
So you can figure out exactly where you are in line, because since USCIS stopped publishing their inventory back in 2017, no one knows where they stand. We don't know how many 485s are pending today in EB2 or EB3. We don't know of those how many are family members versus how many are the primary applicant. We don't know of those how many also have EB3. We don't know any of that. Now, we have requested all of that information through a Freedom of Information Act request. FOIA, Stephen Brown in our office has filed that. And so we're going to be getting that data. The problem is we don't know when we're going to get that data, because USCIS routinely does not comply with the mandated time frame for responding to a FOIA request, which means we have to sue them to get them to respond. So we've submitted the FOIA request. We have not hit that time frame yet. As soon as we do, we are going to be suing them for it. And then as soon as we have that information, we'll be able to provide a lot better details on when these dates might move. What we do know is from prior lawsuits, I believe it was around September 2022, and this is very old data, so my numbers may be off a little bit, but if I recall, there were already about 30 to 40,000 485s for India that could not be adjudicated before the end of that fiscal year, and we're going to remain pending, roll over to the next year. So with that number of 485s and the number of green cards that can be approved for India because of the 7% cap and because of the lack of family-based spillover and because of the lack of EB1 spill down and the lack of EB2 fall across, it is likely to be 10 years to make it through just those 485s that were still pending as of September 2022. That's our best guess. Now, again, we don't know how many of those people have two 485s or are in EB2 and in EB3. Some of those people are bumping up into EB1, so they may move out. So we have some family members that got stuck where their main applicant got approved and the family member is still pending. They're now trying to get into the family-based F2A category, which is also backlogged. So some people might be moving out of these categories, but we just don't know who is actually in the pool of all the applications. So very long answer to say we don't know, but we're trying to find out.
Great. Thank you, Ernest. So that's why maybe Biden is passing the AI bill or something coming up. Maybe that will give the data science to this USCIS to get the data correctly for us. Maybe we have to wait for another couple of years to get these numbers. That's my thought.
Yeah, and so we have this AI executive order that makes AI more eligible for national interest waiver or EB1A categories. But if we are not doing anything about the green card backlog, it's not going to help anyone that's from India, because EB2 is still only going to have so many green cards available. So as of now, that executive order might help in some ways, but it definitely does not solve the green card issue.
Correct. That's what yeah. So I mean, I'm a bit frustrated. I know there are many like me are frustrated because our kids will go aging out soon, like down the time, maybe down a few years. Yeah. Thank you. Thank you for your answer.
Thank you, sir. Thank you so much for calling, Andy. Appreciate your call. right, let's take our next caller. But there is one question I'm noticing here. This is from Shining Shreya. She says, the bill is drafted and championed by Immigration Voice, the only advocacy groups for Indians in backlog. Reddy and Newman, as a part of AILA, has opposed this bill in the past. Will you oppose it now? Is there, Emily, is there any, can you give us some background as to what might have happened or if this is true?
So Rahul Reddy and I are both members of AILA, the American Immigration Lawyers Association. That does not mean that we agree 100% with everything that AILA does. AILA, we join it because it provides education for us as attorneys. It helps us keep up with all the latest trends. And so I'm joining AILA for those reasons, not necessarily for their advocacy efforts or lack thereof. You are correct that AILA did not come out to support this bill. They didn't in public oppose this bill. I can't say what they did behind closed doors. I have no idea, but I do know that they specifically did not support the bill because many of the members have a lot of clients who are from rest of world, and they felt that their clients would be harmed by it was one issue. And there are a number of attorneys that say this doesn't fix anything because it doesn't increase the cap, which is true. Totally agree with that, but it's a step. So I think that that is a little short-sighted. It's like saying, well, you know, because it doesn't increase the cap, we're just going to go ahead and keep making one group of people wait 100 years for the benefit of everybody else. Like, how is that fair? How is that right? So I disagree with that stance. I think we still definitely need comprehensive reform. We definitely need many other things to be fixed in employment-based immigration, but this is a start. And if we can get this across the line, I think it will make it that much more likely that other things will be able to be accomplished in the future. So Rahul and I never opposed this bill, either in public or in private. I think there are people that say a lot of things about us that are untrue, but I can say I've never opposed it. Rahul's never opposed it. We have been actively trying to help people promote it. We've written so many template letters to try to help. We've on our weekly show every Tuesday, we've given you the updates on what's going on with the bill, told you how to advocate for yourselves for the bill, and we'll continue to do that. So hopefully people can see the real us and that we are on your side on that front, because I think that our employment-based immigration should not be based on where you're from. That has nothing to do with your skills or your merit qualifications at all.
Got it. And Emily, thank you for answering that, because I think it's important for us to address such questions too, because our show is all about being very open, put it out there, being honest, and and like you said, just because you're a part of some organization, it doesn't mean that you support everything or everything that they stand for or they do in its entirety. So thank you for making that important statement as well. We really appreciate that. And for those who had any doubts, you have it right there from the horse's mouth that they are not, in any way opposed to this. In fact, we have been talking about this on our show for a long time, and we're hoping, fingers crossed, that, this per country limit goes away to help a lot of people who've been waiting forever for their green cards. All right. On that note, thank you, Emily, and we'll take the next caller. All right, caller with number ending in 2851. 2851, we're ready for you now. Hello? Caller with number ending in 2851, we're ready for you now. Hello? Okay, let's try taking this caller in a little bit. We'll try a different caller, please. Okay, caller with number ending in 6842. 6842, we're ready for you now. Hello?
Hi, Nitya ma'am. Hi, Emily ma'am. Good evening.
Hi, sir.
So my question is regarding the... Hi, ma'am. Good evening.
Please.
So my question is regarding the H4 stamping. So my H1B extension was approved by USCIS last month, and my wife, she is an international student in Canada. Her current H1 visa got expired on September 30th, and she has actually got the appointment in U.S. Consulate Toronto. So my question was, can she go for H4 stamping without my stamping is done for the H1B extension?
Yes, she can. Yep, no problem with that at all. So just make sure she has copies of all of your H-1B approval notices, your I-94, and your previous H-1 stamp or whatever stamp you entered on, plus the marriage certificate, but it's not required for you to go for stamping to allow her to go for stamping.
Okay. Thanks, ma'am. That's the only question I had. Happy Thanksgiving. Thank you so much.
Thank you, sir.
Thanks,
Thank you so
you
much for calling, Annie. Okay. All right, let's take our next caller. Okay, caller with number ending in 8482. 8482, we're ready for you now. Hello?
Hi, Nitya Garu, and hi, Emily. Thanks for taking my call.
Hi, sir. Thank you for calling. Please go ahead, sir.
So I have a question to Emily that I have applied for H4 and H4 EAD extension, but while applying, I used my spouse company A's H1B copy, but whereas after I applied, I realized that she had changed the company B and she had got one more H1B approval copy. And while applying, I did not use the latest one. I used the company A's H1B copy of my spouse. So my question is, does this going to cause any problem in the approval process?
Is the company A H-1B still valid? Like, has it expired?
No, it's still valid. The company A's
Okay.
H1B, H1B is going to expire in December 2025.
Mm-hmm. And when does company
Yeah, and
B's
the company
expire?
B's H1B copy is expiring in December 2026.
Okay.
So
Okay,
while applying
so-
my H4 and H4 EAD extension, I used the company A's H1B copy, which is going to expire in December 2025. So, yeah.
Gotcha. So it's not going to cause a problem for you at all. Ultimately, you'll still get the H4 EAD. There are two potential issues. One, they may give you the H4 EAD only till December 2025 if they don't realize that she's gotten an extension since then. So what you may want to do to avoid that is check your H4 and H4 EAD receipt notices. Down on the bottom left corner is going to say which service center that they're pending at. Send a letter to that service center with a request to interfile her new H-1B approval notice into the file so that you can get the approvals till December 2026 instead of 2025. Now, what I do see is a lot of times they still will approve to December 2026 anyways, even if you didn't actually submit it, because they should have that information in their system. Just kind of depends on the officer. So that's why I would say go ahead and send it in just in case. And so that would be one issue, is you just might get a shorter approval. The other issue that we see rarely is if company A, now that she's left that company, withdraws that approved H-1B and they don't realize that she has the new one, sometimes you'll get an RFE asking for, show us that she's maintaining H-1B status, and then you can submit company B's approval in her last 3 pay stubs and you'll still get the approval and everything's fine. So that's about the worst thing that might happen. So you'll still get them even if the new H-1B approval wasn't submitted at the time of filing. You just might have either an RFE or a shorter approval.
Okay. Yeah, that's all I wanted to know. Thank you so much.
Mm-hmm.
Thank you, sir. Thank you so much for calling in. All right, let's take our next caller. Okay, caller with number ending in 8604. 8604, we're ready for you now. Hello?
Hello.
Hello, sir. Thank you for calling. Go ahead, sir.
Hi, Nitya. Thanks for taking my call.
Sure, sir. Please go ahead.
Yeah. Hi, Emily.
Hi.
Yeah. My question is, I'm on H1B and my priority date is 2015 March. So I have 2 kids, and first kid is 22 years old. He's already on OPT. He completed college education and he's working. So my question is, he's in the first year of OPT and computer science graduate. So he's eligible for 2 years of STEM extension. So my question is, he completed his graduation in 2022 December, and he joined in a company, in a US recruitment company. It's not a Indian company, and they recruited him for a client on contract to hire basis for 9 months. So his contract started in January 2023, and it was supposed to end in 2023 September. But in September, his client company said that they have some budget issues, and his contract is extended up to January 15th. But his OPT for first 1 year expires on January 1st. So he is now trying to renew or apply for OPT STEM OPT extension for next 2 years. So he wants to apply for that. For that, he needs I-983 to submit to his college so that they will issue I-20, and then he can apply for STEM extension. However, the consulting company, which is a US company, they say that no, you will be acquired by your client and they will give you I-983. And the client company says that, okay, you are really good and we will take you, but we may give you the appointment in December 1st week or 2nd week. So my question, Emily, is neither the client nor this consulting company is able to give him I-983. So what is your advice to apply for STEM extension?
Well, he definitely needs that to submit to the school in order to get the I-20 that he needs to submit with his STEM extension. So if neither of them are going to be doing it in time, it looks like he needs to be looking for another job that is an E-Verify company and that will be willing to do that 983 so that he can file the STEM extension. Just make sure, be very careful about the company. There have been previous companies that we know of that were fake companies that were, giving offer letters to so-called help people that were getting near the unemployment limit. This was Integra, AZ Tech, and Wireclass, that group of companies. So I say that just to say that if you don't want to get into a stressful situation where you panic and do something stupid and get an offer from a company that doesn't exist. So make sure that you find the right company and get that 983 submitted earlier rather than later and file the 765. And if it works out to where the client or the consulting company is later able to move forward with his position, he can always switch to them in the future. But for now, you don't want to delay getting that STEM extension filed. So I'd be looking for another employer at this moment.
Oh, thank you, Emily. Actually, he attended a couple of interviews with good companies, and they are also ready to offer him. So I think your advice is good. So he will take that offer, and then he will provide that offer letter to his university, and they will give him I-20, right?
So he needs to provide the I-983 to the school to get the I-20.
Okay. Yeah. Offer letter and I-983. Yeah.
Yep,
that's good.
you got it. Mm-hmm.
Okay. Yeah, because otherwise on January 1st, 2024, he has to leave the country if he doesn't apply for OPT STEM extension.
Yeah, I mean, he would have the 60-day grace period, but definitely you don't want to waste 2 years of, OPT time when he's completely eligible for it. So I would definitely be accepting an offer from a new employer at this point.
Yep. Thank you, Emily.
Yep.
Thank you so much for calling, Andy. Appreciate it.
Thank you, Nitya garu. Bye.
Okay, sir. Sure. Emily, before we take our next caller, let me just go through a couple of questions. Just give me 1 second. Okay, this is from Shriku. Says, I'm moving to H4. I have an approved I-140 and my wife who's on an H1 is not having an approved I-140. Can I get H4 EAD with my approved I-140?
Unfortunately, no. It only works based on the H-1B spouse's approved I-140. So you can't use your own I-140 to qualify for the H-4 EAD.
Okay. Got it. Does the bill increase visa numbers? What about those doing consular processing? Does consular processing also get EAD and advance parole 2 years, after 2 years?
No. So number one, it does not increase the number of green cards at all. So we do definitely need additional reform beyond that. And it does not provide for the EAD or AP if you're outside the country requesting consular processing. That being said, they are reserving 25%. So they're basically, where was that? Of the percentage that are reserved, they're reserving up to 25% of those for people who recently came to the U.S. That haven't already been in the U.S. in the last 4 years. I don't know exactly how that's going to work, but that may be one way that you can still qualify, but you have to have a way to get to the U.S. to be able to file the 485 in that situation. And they don't give the EAD or AP to someone who's outside the U.S.
Okay. Gotcha. And question from Sam Reddy says, my wife is an international student in Canada and she has an H4 interview appointment with the U.S. Embassy in Toronto. Can she go for an interview first, even though my H-1B stamping is pending? I will be in the U.S.
Oh, yeah, I think that was one of the calls we had.
Yeah,
and
I
yes,
just
no
wanted to
problem with
confirm
that.
that
Yep.
it's the same one. I don't like to miss some of these questions. Just in case.
Yeah,
Okay.
so even though he does not have the stamp yet, as long as that H-1B is approved and he's in the U.S., she is eligible to go for H-4 stamping based on it.
Got it. Emily, which brings me to the other point about them wanting to start doing these H-1B stampings in the U.S. itself without having to go back to India. Has there been any further updates on that as of now?
So the last we knew, it was the regulation that will implement it was given to the Office of Management and Budget. That's the OMB. That basically they're an agency that reviews every other agency's regulations before they publish them to make sure that there's nothing between agencies that are going to conflict with each other. So it was submitted to OMB for review. So as soon as it gets out of their review, assuming that they don't need any changes to it, we should have a published regulation shortly thereafter. We also know that in Biden's executive order on AI, it did include a directive to make sure that visa stamping is available for those that are working in AI. So hopefully that will also help speed up the process. But as far as timeline and actual physical steps we can see, nothing new.
Okay, got it. Thank you so much. Okay, let's take our next caller, please. Okay, caller with number ending in 1177. 1177. We're ready for you now. Hello?
Hello. Can you hear me?
Hello, sir? Hello, sir. Thank you for calling. Yes,
Can
we're
you
ready
hear
for
me?
you, sir. Go ahead, sir. Yeah.
My question is, my employer applied my perm in October 2023, and my 6-year max out is in November 2024. So when is the right time to file that 1-year extension if the perm process crosses beyond 365 days? So do I need to wait until 365 days crosses, that is October 2024, or I can apply before for the 1-year
You
extension?
can apply before. So is your current H-1B valid till November 2024?
Yeah, November 2024,
Okay.
and my perm is applied in October 2023.
Okay, so you will basically meet the requirement in May, even though the perm has not yet been pending for 365 days, but for the start date that you're going to be requesting in November, it will have met the 365 days by that point. So you can file it 6 months early in May 2024 to get a 1-year H-1B, or you can wait and see if your perm and I-140 could get approved by November and then file the 3-year H-1 extension. So some people like to wait and see and hope to get the 3-year instead of dealing with just a 1-year H-1B. Other people just want to get the 1-year locked in so you know you're good. So just kind of depending on how you and your employer feel about that, you have either of those options.
Okay, but I'm good to apply in May month itself, May 2024
Yes.
itself for the 1-year extension?
Correct. Even though your perm is only pending for 6 months at that time, you can still file it early.
And one more question, just in case if I lost my job and my job is ended, so does it going to cause my perm approval process to be denied for that? No, right?
Not automatically. Depends on if your company chooses to inform DOL to withdraw the perm. And if they don't, the process will still continue. Assuming it gets approved, the company would just choose not to file the I-140, let the perm expire, and then the process is over. So if that happens, you don't get to keep that priority date.
Okay, but if the employer wants, even though if I lost my job and if the employer wants to continue my perm, I mean, once the perm gets approved, and even if the employer wants to file for I-140, can the employer do?
They can, but they need to be actually offering you the permanent position. Still, you don't have to be in that position right now, but they still have to be willing to offer you that position. So that may be hard for them to do if the position no longer exists, for example. So it really kind of depends on the company and whether they're willing to offer you a position in the future, even if they don't have a position for you today.
Oh, okay. So in that way, they can show up to USCIS and get the I-140 approval, right?
They could, yeah, if they have that future position available still.
Okay. Yeah, that's all I wanted to know. Thank you.
Thank you, sir. Thank you so much for calling in. All right, let's take our next caller. Okay, caller with number ending in 8296. 8296, we're ready for you now. Hello? Please press *6 to unmute your line. *6 to unmute your line.
Yeah, can you hear me?
Hi, sir. Thank
Hello?
you for calling. Yes, we can hear you, sir.
Yeah, hi. Hi, Emily. Hello, and each other. Yeah, hi. Yeah, my question is to Emily. My name is Ajay. I'm having my 485 pending for March 2013 is EB2. And my son also in EAD. Since 3 years he is studying in Georgia State. Next year fall is going to college. So now he is applying to the college. So we have a doubt because a couple of colleges we applied, they consider as a out of state like that. So now in state we are applying. So after applying the application, is it because he is in 485 EAD pending? So to consider as a local student, so is it, what is the better approach we need to proceed? Do we need to go to the college, university college and explain them, or just put an application online and leave it? So is it better to give a call them and explain?
I think partly it depends on the application and what kind of questions it asks, because we're finding some college applications don't have an option for 485 pending or GCEAD. They only have a non-immigrant option or green card holder option. So if that's the case, I would definitely give them a call and explain the situation. If they're unsure or not understanding, you can always get a letter from an attorney that explains exactly what your status is and that you are lawfully present, and that most schools consider that for resident tuition. It's the same as being on a non-immigrant status, basically. So yeah, you may need to give them a call to explain, and probably do that before submitting the application if you have time.
Oh, okay. Okay, I'll do that. While submitting the application, prior to that, I will give a call them and explain, and I will see their recommendations. Okay.
Mhm.
Thank you,
Yep.
Emily.
Thank you, sir.
Yep.
Thank you so much
All
for
right.
calling in. Thank you, sir.
Yep.
Okay. All the very best. Bye.
Thank you.
Okay. Let's take our next caller. Okay. Caller with number ending in 1 second. 8482, 8482. We're ready for you now. Hello?
Hi, can you hear me?
Hi, sir. We can hear you, sir. Thank you for calling. Please go ahead.
Okay, I have a question. So, I and my wife were working on H-1B. So we both are working on H-1B and I-140 approved. So we had a court marriage here in US, and we are on H-1B working. So my question is like, before to this, I had a marriage in foreign country, and we lived here in US. But after 2 months of that marriage, it did not work out, and we got separated and did not got divorced. She just left me and without contacting me and without coming into contact. And I married legally to another person. So we both are working here on H-1B. So if my current wife has came to know about these things, and if she complains to immigration, or if she complains in a police station, will I be arrested or will I be get deported from US? What is my situation?
No. So she's not on H-4, correct? She's on her own H-1B.
Yeah, we both are on H-1B. But
Okay.
before to her, I married to another woman in the foreign country, and we lived together in US. And after that, we separated and did not divorce. And I married another woman in US, and that was a court marriage here in US.
Yeah. So basically, your second marriage is not going to be considered valid because you were not legally able to marry someone because the divorce did not happen. So as long as you're not trying to get your current spouse on an H-4 or file a green card with her as a dependent, you just have to go through the process of getting the old marriage taken care of and then get married again to your current spouse if you want to do that. But it's not anything that's a criminal matter. It's not anything that's going to harm you immigration-wise, as long as you're not relying on this second marriage for your spouse to get any kind of immigration benefit.
So what if my current wife complains about me that I am married previously and did not get divorced, and if she complains to immigration or if she complains in the police station, will I be arrested or will I be deported from US?
No, it's not anything that has anything to do with immigration, and it's not a criminal matter, so it's nothing that you can be arrested for. It's just her current marriage is not valid.
Oh, okay. So it's not going to harm me anything, right? Okay.
No.
Okay, yeah, that's all I wanted to know. Thank you.
Thank you, sir. Thank you for calling. All right, let's take our next caller. Okay, caller with the number ending in 2851. 2851, we're ready for you. Please press star 600 to unmute your line. Star 6 to unmute your line. Hello?
Hi, Nitya.
Hi, sir.
Am I audible?
Yes, sir, you're audible. Thank you for calling, sir. Go ahead.
Hi, Emily. Good evening. Thanks for taking my call. I got a quick question about the grace period for H-1B laid off employees. And I know there was some compelling thing for 140 EAD in the past. And also there was the Presidency Advisory Panel has recommended in the past that there is a grace period of 180 days. I'm unsure of that. Was that recommendation was materialized in any way, or it was still a 60-day notice?
It was not materialized in any way, so it's still just 60 days.
Oh, it's still a 60 days. Okay.
Yeah.
Okay. Thank you.
Yes, sir. Okay, that was easy. Thank you so much for calling.
Thanks, Nitya.
All right.
Yeah.
All right, folks. I know we have a lot more people waiting on the live chat as well as people calling in. But unfortunately, as always, we always keep running out of time. Emily, I'd like to take a minute and thank you so much for being on the show today and for helping all our viewers. Thank you so much.
You're very welcome. Have a good Thanksgiving to everyone.
Yes, happy Thanksgiving, everybody. And we'll see you all same time, same place next week. Be safe, eat a lot, spend a lot of time with your family, and we'll come back with lots more questions and we'll be right here. Thank you so much. Okay, have a nice day, guys. Bye.